Okay, abusia yɛbɛ mma kwa basompo so ɛde POG Media so. Yɛde bɛkɔ political highway ne so highway ne deɛ ensɛm bebree wɔ so a yɛn so yɛagye pene sɛ bɛmi abadwafoɔ no ahu deɛ ɛrekɔ ɛne deɛ ɛreba. Yɛn mbɔ nwura yɛn nsɛm no mu. Ɛyɛ former Chief Justice Atuguba ɛna ɔde ensɛm bebree aba abɛto dwa a kyerɛ sɛ watru hot fire asan so a expose ɛyɛ Chief Justice Torkornoo a enye asem ketewa kra eye ne ruling na o ruling ye in favor of eye NPP etese 4-seat vacant abam Bagbin o declare no etese case nkopi mo Supreme Court no wabua asem no abo eye abam Bagbin sisi ano eye Mr. Atuguba eba abonten no or say sa case we plan kini kwan say epiemu ewo Supreme Court and ke High Court a case but enam say Chief Justice no oye in favor of NPP no eno intina oye sa nneoma nyina ebusua okan say mwatoto bia mane Chief Justice and the Supreme Court judges no abam Bagbin no wa true massive support at the amana say afenyo markings ne Chief Justice ne de waye omo pasa amom yanko na yanko nkoti big thanks to Joy News omo ene this information omo ma exclusive interview na answer na be kono o ensem kan bi afahye the comment section like na share ma from so answer into me enkabi bedamase.
Here from the home of retired Supreme Court Judge William Atuguba, and it's about the outcome of or the decision of the Supreme Court this morning regarding whether or not 4 seats declared vacant by the Speaker of Parliament should stand. And the court decision is quite clear, 5-2 in favor of the application put before the court by the majority leader, Alexander Afenyomarkin, and of course the MPP side in Parliament. Now in the 5-2 majority decision, the Supreme Court interpreted Article 97(1)(g) and H of the Constitution to mean that an MP vacates his seat only during the term of Parliament and not during the future Parliament. The effects of the court decision means that the ruling by the Speaker declaring the 4 seats vacant was unconstitutional, and therefore the 4 MPs have by law not vacated their seats. So how are you reacting to this? But then we can get the reaction of an expert who is seeing it all. He sat through most of these landmark cases at the Supreme Court and has a better understanding of what went into the decision and whether or not they got it right. Remember, as we await the reason behind the ruling tomorrow. Retired Justice, you're welcome to the post.
Thank you.
And if you can kindly bring up the microphone. So
okay.
I'm sure you follow the news. First, let me get your initial reaction to the decision by the court 5-2. Saying that what the Speaker did essentially was unconstitutional.
Well, I think earlier on I had spoken on this issue when Afenyomarkin filed his writ. I think forgotten the TV station.
I think and he also spoke to us as well.
Oh, okay. And I expressed my views at length on the issue of jurisdiction.
Right.
Well, I still stand by it. I cannot dilate too much on the issue because the reasons
are yet to come.
And with court matters, you have to tread very carefully because of the law of contempt. Although personally, well, I think so far the court, after some time, they've been more liberal about that issue of contempt,
right?
Which is better, except in situations where people go way overboard. As far as the issue of jurisdiction, I think it was just the jurisdictional matter.
The reason why the two abstained?
Yes.
Right.
But the majority said that the Speaker had erred
essentially
in declaring the seats vacant. Well, I think next time you get the text of it for me to be able to speak more confidently.
But in terms of the jurisdiction,
yes,
is it a case that they didn't have the right to go into the case from the word go? Because this was a matter that invited them to interpret the Constitution. That is the duty of the Supreme Court.
Yeah. Well, you see, constitutional matters are very involved. There is a whole spider web of provisions which stand, if you take them in isolation, yes, they mean what you have read. But they are not intended to operate in isolation because the Constitution is a whole legal framework and it's not intended to create. I see. It's not intended to create inherent strife or conflict, amongst its own provisions and the pursuant interpretations of them. So there must be cohesion. There must be read as a kind of studied and structured document designed to put in place a certain framework of government. So let me give you just a small example.
Right.
If we look at Article 125.
I can help you with this once you go through the
125.1 also 126, 125, 1 or 2 thereabouts. So okay, 125.1. Justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. Now, that's clause 1. Clause 3, the judicial power of Ghana shall be vested in the judiciary. Accordingly, neither the President nor Parliament nor any organ or agency of the President or Parliament shall have or be given final judicial power. Now, more to the point is clause 5. The judiciary shall have jurisdiction in all matters, civil and criminal, including matters relating to this Constitution and such other jurisdiction as Parliament may by law confer on it. And then listen to this. Composition, a mode or exercise of power of judiciary. 126 clause 1. The judiciary shall consist of A, the superior courts of judicature, comprising the Supreme Court, the Court of Appeal, and the High Court and regional tribunals. B, such lower courts or tribunals as Parliament may by law establish. 2, the superior courts shall be superior courts of record and shall have the power to commit for contempt to themselves and all such powers as were vested in the court of record immediately before they come into force of this Constitution. So you see that this Article 125, clause 5,
right,
is saying that the judiciary shall have power or jurisdiction in all matters, civil and criminal, all. And then you've seen the composition of the judiciary. consists of down to the lower ones. Now, one would have thought that any court at all, which is part of the judiciary, can exercise all the jurisdictions in civil and criminal matters, because the powers are given to the judiciary.
Right.
They are part of the judiciary. But that's where the complexity comes, because as you go further down, you see, as Mosechi J explained in some case, I think in the 80s, that yes, this power is there, it's given to the judiciary, but the power has been shared out to the various branches of the judiciary. So it doesn't mean that once you are a part of the judiciary, you can exercise all those powers, because they've been distributed. So you exercise them according to the allocation distributed to you. You see the complexity there.
Right.
And so when you look at the blanket statement, judiciary shall have jurisdiction of all civil criminal matters. And the judiciary is stated in terms of the court system. And when you look at it and say, oh, any court at all can exercise all those ones. But as I said, the subsequent provisions
are there. The question people are asking is whether the Supreme Court erred in going into this case at all.
That's what I'm coming to. That if you look at Article 130, clauses 1 and 2, in Article 2, if you read those on their face, they invest exclusive jurisdiction concerning the interpretation and enforcement of the Constitution. You know, exclusive jurisdiction, except in the fundamental human rights. So, prima facie, you think that in all matters concerning interpretation and enforcement, except when it comes to fundamental human rights, the Supreme Court can interpret and enforce any matter, however arising. That's where the trouble comes. Not however arising, because the subsequent provisions, for example, have given jurisdiction to the High Court in parliamentary elections,
right,
including this question of vacancy. They've given it to the High Court.
Right.
Notwithstanding Article 130, notwithstanding Article 2. You know? Then also, you look at chieftaincy, jurisdiction chieftaincy matters. The Constitution has set up the system of chieftaincy tribunals, highest being national tribunal. The ordinary courts are excluded from handling chieftaincy matters, except when they get to the National House of Chiefs. You are not satisfied, you apply for leave from the National House to appeal to the Supreme Court,
right,
only Supreme Court. If they refuse, you can apply for leave from the Supreme Court. If you fail, then that's the end of it.
So in this case, your thinking is that the High Court should have handled this matter?
That is it. But this
was a matter that invited the Supreme Court to interpret. The High Court is not clothed with that powers.
Yes, there's complexity still. When a matter like this comes up, now I'm saying that because I said it before.
Right.
And so I'm only saying that I'm standing by what I said. When they give the reasons tomorrow and I feel persuaded, I can call and say, oh,
you did well.
I was wrong. You can do that. But for the meantime, that you have come, the best time would have been tomorrow after their reasons. And we will do.
Right, so
opposite answer.
Justice William Atuguba is my guest. We are getting reaction on the Supreme Court ruling this afternoon. We're explaining.
Yes. the same Constitution is not unaware of Article 130, clauses 1 and 2. It's not unaware of Article 2, which on their surface have given exclusive jurisdiction about interpretation and enforcement. But they've gone, nonetheless, to make this specific provision. Now, we have a certain maxim of interpretation of statutes, which says verba generalia specialibus non derogant. I say special provisions, special matters, general matters, general words do not override special words. So if you have a general provision, which standing by itself will also encompass the jurisdiction given to a lower court, because verba generalia specialimus non derogant, the general powers will be confined to the area which will not intrude into the special power of the special provision. That is so Articles 130 and 2, these are general provisions. And according to this rule, general provisions don't override specific provisions. And so once the specific power about vacancy of seats is given to the High Court, the general powers hanging there cannot override the special provision. Otherwise, that special provision will be rendered completely hopeless.
Meaning the Supreme Court had no business going into this.
Yes, I'm coming. They have a kind of, what do you call it, referential jurisdiction.
Right.
That's to say, this matter, which is a vacancy of parliamentary seat matter, is for the High Court. However, if the parties there contend that some legal provision relating to this matter is ambiguous and it's a constitutional provision, then Article 132 requires that the High Court will stay the provisions and refer just that issue of interpretation to the Supreme Court.
In this case, this was not done.
This wasn't they went straight.
Or this was not exploited.
It wasn't exploited. It wasn't exploited. And number two, you see, the question of even the referral, when the issue arises, it doesn't mean that any time it's alleged that there's an issue for the interpretation, the High Court automatically must stay this. It will have to consider whether the provision in question is actually ambiguous. If in its opinion it is not ambiguous, can proceed with the case.
But the Speaker, yes.
If a party is satisfied, can go to a Supreme Court on supervisory jurisdiction to quash the view of the High Court and order it to refer that issue to it, or refer the issue to itself for determination. And after they send that determination to the High Court, and they dispose of the case insofar as the issue requiring interpretation is concerned. But then the final determination of the matter is from the High Court.
Justice, yes. This is a case where an arm of government, the leader of an arm of government, gave a ruling based on his understanding of what the Constitution says. And then a member challenges that decision. Clearly, one would say that the Supreme Court was the avenue or the platform to bring finality to this matter.
Yes, but their finality is governed by the same provision. The finality will come when the court, given that jurisdiction over that specific matter, has difficulty, or the parties have raised a difficult interpretational matter concerning it. They say, oh, okay, this thing is not that clear. So they are bound to refer to the Supreme Court. That's how the Supreme Court comes in. That's how the Supreme Court will come in. But not ab initio. That's just straight away. It's the same constitution that has made that provision. And this Zanato, she stood for the primaries of, is it already or something?
Kwale constituency.
Okay, I don't even know the question, but
Kwale constituency.
All right. And she was contesting the NDC primaries with a fellow NDC, I think the incumbent. And she won. Now the incumbent challenged her election as the parliamentary candidate in the High Court on the ground that at the time she was elected as the parliamentary candidate, she was not a registered voter as required by the party's constitution. You see? So they went to the High Court to say that her nomination, her election was null and void, you know. So they were arguing it various ways. Eventually, some young lawyer that night, Edisi Tamaklo. Yeah, he brought an application to the Supreme Court challenging the ruling of the High Court. Because the High Court was saying that it was within its jurisdiction and so on and so on and so on.
Right.
Some lengthy ruling. But then when I went through the whole thing, I saw that the substance of the lawyer's arguments, even if they were not directly couched that way, amounted to the contention that there was an issue of interpretation as to whether, in view of Article 94, I think, of the Constitution, which governs qualifications for election to Parliament, whether that one should have governed the situation. And if it did, then of course the party's ruling could not stand. Because at the time they disqualified her, that she was not registered. The EC had not yet, was far from
publishing opening the process.
Yes, you see. So when they came down, I said, man, this was a situation of the need to interpret Article 94 because it's a supreme law.
Right.
You can have your party constitution, you can, even Parliament can pass an act, and all these are subject to the Constitution.
So if I may ask, I mean, you're on retirement, but
I'm coming.
Okay.
So, and this case was cited by this Supreme Court when they threw out the Speaker's application to set aside their earlier ruling and directive. They referred to it, and that's very interesting because it demonstrates quite clearly that. In that situation, this court didn't say the Zanator's opener was wrong to have gone to the High Court. No, he was right to go there, but when the issue of the proper interpretation of as to when a person can properly be said to be disqualified to contest for Parliament because of non-registration as a voter arose. That one was not, it required the interpretation of Article 94 vis-a-vis the party's constitution, So we referred that, we said the High Court was wrong to say that I could determine all that issue too. So we stayed the proceedings there and formulated the issue should have referred to us, to ourselves. And then subsequently ruled that, on the proper interpretation, it is when the EC opens nominations.
Before you can challenge.
And not even open only, when it has closed, open and closed. And you have not registered, but you purport to be a candidate. They can challenge you.
So, for example, if
you go to even register with the EC and they find that you have not registered, they will accept you. Unless, of course, you quickly go and register before the close of nominations.
So, if I should do some deduction here, for example, if this case was brought before you, your inclination would have been that the matter should go to the High Court.
Yes, we would have said that they were wrong in coming straight to the Supreme Court, whereas the specific jurisdiction about this specific matter is lodged in the High Court.
So why would the current Supreme Court panel overlook this and then go ahead to make this pronouncement?
Well, there are decisions, I don't know whether they were cited to them. If they had gone by those decisions, there are seen quite clearly that they should have said no. Afenyo Markin was wrong to have come in the first place directly to them. They would have said that. Well, I mean, that is to say, if they follow the precedents, but in the course of time, and that's the trouble now, because in the course of time, when I was there came a certain stage, I used to tell some people, somebody will ask me the law, so I said, I don't know what the law is, because, today, the principle is laid down this way. It was laid down some years ago. It's changed today. Some other panel will come and, state the opposite, and this same members later will go back to the other. Confusion. This is what has happened now. So there's no certainty in the law. But if you look at it carefully, the weight of judicial precedence on the matter is quite clear. I can give you two examples. I'll give you the Zanator one.
Right.
There was a case, I think it's one. There's a chieftaincy provision. If you are convicted of a crime of dishonesty or something, you can't be a chief. So they brought an action against a chief. They said he had been convicted, so he should be disqualified as a chief. And the Supreme Court said, but this matter is for the chieftaincy tribunals because
to take a decision.
It involves the distillment. The effect is to distill the chief. So that process is given to the chieftaincy tribunals. If they go there and issue of interpretation, they can refer it, but not like they threw it out.
Okay.
In the case of former Chief Justice Aban, there was this defamation case against one MPP. I've forgotten his name. The 31st December case, it's a holiday case. When they decided it, one lawyer, I don't know, I've forgotten his name, he said that when he was sitting in court, he heard Chief Justice Aban referring to the editorial of the Daily Graphic, that he was quoting from the editorial. He was quoting a passage from the editorial of the Daily Graphic. But subsequently, when he realized that it was not so, it was rather in some other column, I think his claim was that Justice Aban then varied his judgment to refer to the non-editorial part, and that he was being dishonest, he was not fit to be a judge, so and so and so and so. So subsequently, they brought an action that C.J. Aban was not fit to have been appointed Supreme Court judge. So they should declare that his appointment was null and void. Now the Supreme Court looked at it, and they said, well, you see, prima facie, the question they brought is whether he was properly appointed in accordance with the Constitution. And so, looking at 132, clearly, you say straight away that the Supreme Court had jurisdiction.
Okay.
But what did they say? They said the effect of the relief they were seeking was to remove Aban from the bench. And the procedure for removal of Supreme Court judges, Superior Court judges, so that 146 or so. And so that is what should govern the matter and not Supreme Court.
All right.
I get the idea.
Few issues here. I mean, hopefully tomorrow the reason will come.
Yes, as I said.
And then we'll better understand.
If I read I'm convinced.
The motivation behind the position that they've taken.
Yes.
But until the decision is challenged, this is what we will have to live with. What do we expect the Speaker of Parliament to do?
Oh, in the face of this decision, well, he's bound by the decision of the Supreme Court. He's bound by it.
I have heard the Member of Parliament for Savdai, Rosen Dafiameko.
Yes.
He makes the point that only Parliament can give an effect to the decision by the Supreme Court. Is he right? Oh,
of course it's addressed to them. But it doesn't mean that if they fail to comply, they are the only people who can. That's true. There are processes. Contempt is there, and it's a high crime. Can be prosecuted, and you have to suffer imprisonment up to 10 years.
That is if the court decision is not complied with?
Yes, up to 10 years. It's not necessarily 10 years, but you must there's no option of a fine. You must just suffer some term of imprisonment, not exceeding 10 years. And not only that, 10 years disqualification from holding public office. If you are president, you are liable to removal as president. They're all there.
Right. So Parliament is on recess now.
Yes.
For example, if tomorrow the Speaker says that MP should report to the House for business to start, you expect the 4 MPs to both to the chamber and assume their seats?
In line with the Supreme Court decision. That is what is governing the situation now. Yeah. But the interesting thing is, that's why, anyway, you see, matters, this country, we want to pretend, but politics has entered everywhere.
Why do you say so?
I mean, I'm coming. Politics has entered everywhere. These politicians, you know how they operate. They are not interested in the righteousness of the matter, the correctness, but the party inclination. And that is what they use. So even somebody can know clearly that what he's standing on is wrong, but he will push it. And, a court is a court. If you persuade it for whatever reasons, I don't know, it adopts your view. That is it.
Before the ruling came, comments that we read on social media, comments from social commentators, even politicians, some created the impression that it was going to go the way it did. There appears to be some kind of confidence. People appear to have reduced their confidence level in the judiciary to be impartial in the adjudication of cases. Did you sense that is what is happening?
Oh, but you people are the authorities in this field. Afrobarometer and all these sort of things. When comments from the public are made, you are the people who pick them up, so you know better. I mean, social media, you can just see. I don't think we have ever reached a stage where people easily will express loss of confidence in the courts, as is happening. From Afro Barometer to the local citizens. I mean, on a daily basis.
Are these comments not politically motivated?
Some may be, but if an issue is right, it does not matter that some are using it politically. It remains right. See what I mean? So the question of politics, it clouds the matter. But if people want to stay right, you can isolate the pure legal nuances of the situation and go by them. That is it. So, me, as I said, I'm subject to the Supreme Court. I was there, I'm no longer there.
Right.
Even when I was there, I was subject, I couldn't just do anything. If I did something contrary, they could bring an action also. Oh, sorry. I'm not used to it.
Yeah, I mean, because you've been there before,
yes.
The question would then be asked,
Yes.
when you were there,
yes.
Is it a case that some of the decisions that were taken had some influences outside of what the law says?
Well, that's anybody's guess. It's not a legal question. When the public have been ascertained to have lost massive confidence in the jury, it's a legal matter. As I've always said, the courts belong to the citizenry. They are the sovereign owners of Ghana. Sovereignty resides in the people. And in fact, even the administration of justice, let me read that.
So Justice William Atuguba is, I guess, here on the poll. The 1992 Constitution. Okay. We are just trying to understand. Right.
Those who are not convinced. Justice emanates from the people and shall be administered for and on their behalf by the judiciary in accordance with this Constitution. So they are the repositories of justice. The courts there are their agents. And that's where we lose out from the proper perspective of the constitutional order. We are agents of the people for the administration of justice, and their views matter.
But this happened before coming here.
Yes.
I went through the appointment procedure in terms of appointing somebody to the Supreme Court, to the Chief Justice.
Yes.
Even though it's done by the President, he does it in consultation with the Judicial Council, sometimes with the Council of State, and then approved by Parliament. So the process is such that there are checks and balances. Why would people think that because certain judges have been appointed by the President, they will toe towards the line of the government in question? Well,
let's take one example. I've nothing against that judge. As a matter of principle.
Right.
This judge is taken from the High Court straight to the Supreme Court. I don't think he has even done 3 years in the High Court. I'm not aware that any decision of his has been published in any law report. What then so qualifies? And this person was MPP parliamentary candidate for whole constituency in 2020, I think. Yes. Now, there are so many other judges.
In fact, during the trial, the lawyer for the Speaker requested that he be allowed to recuse himself.
Yes.
The Chief Justice ruled against that.
Yes.
Because he was there to interpret the law,
in fact,
not to toe the line of any political party.
Oh, but, I mean, you can, therefore, what you are saying, if you go by that, then no question of bias can ever arise in relation to any officer. Is that a realistic thing? These forces come to play. Now, as I've said, why must that person be hoisted like that? What particularly qualifies what? Over and above his seniors in the High Court, in the Court of Appeal. What is there?
10 years of practice and above.
10 years of practice. In what way has he so distinguished himself? You have people who are over 20, 30 something years experience. I mean, let's look at the brass tack facts of a matter and advance ourselves. Because theoretically, anybody can argue anywhere. That's why pretentious positions can be taken and justified in the face of obvious incongruity, dishonesty. There's the trouble.
So the danger here for you is that politically exposed persons add to the perception of bias as it relates to the Supreme Court and the judiciary as a whole.
Definitely. But let me qualify it this way. It's not everybody who has been involved in politics who can be necessarily politically minded.
Right.
I can say, by speaking for myself, somebody like the late Akroma, of blessed memory, I can say that as far as I'm concerned, even though he was in the President's chambers, he was his lawyer in the election petition 2020, if I had my way and that man was interested in going to the Supreme Court, I would have appointed him. Because if a legal issue he will look at it professionally. Can trust Akroma to do that. So the incidence of his politics, you can see from empirical evidence the way he. But look, even this LGBTQ thing, he was probably taking a position nobody expected him to take. And some other media rights, he was...
The right to information and the like.
Yes, he was doing them, even though maybe against the common interest. But he was doing them. There's another lawyer. If he currently... He's a member of parliament. I've never known him, I've never seen him, except on social media. Atuguba.
Yes, Atuguba, a member of parliament for Asante.
Yes, such a person. If I had my way and he was interested in the Supreme Court, I would put him there. Because he's a brass tack MPP, but very objective-minded. Very, very objective-minded.
But why do you think that the Justice Gawu is not objective?
Oh, well, it depends. Look, this man has manifested a certain background. If you look at Atuguba, look at this question of the finance minister, the removal of the finance. He spearheaded it.
Right.
Very strongly and staunchly. Against even, all odds. Then he came out not long ago to say that the political system, the electoral system, has been monetized. He said it, openly. That's an honest man speaking. He even said he had to use his law practice money to help his campaign. And that was bad, that kind of thing. I think he even went out to contest as an independent.
I think
he went back.
He is a member of parliament on the ticket of the MPP and still contesting the upcoming election on the ticket of the MPP.
No, but I don't know whether he did not.
No.
Or he did. Maybe I'm confusing with another man. But you see, looking at some of these traits concerning him, this is a man who will not be bogged down by the fact that he belongs to a party.
The MPP.
So when you have such things manifesting about somebody, yes, you can see a certain trend or principle.
But Justice,
I'm coming.
Yes.
You've made me lose my trend. Yes, another person I have in that vein of thought is Ayikwe Otu.
The former Attorney General.
Yes. Very principled man. Although I was shocked that when Kandapa, the National Security Minister came out saying that
they should balance their rulings.
Yes. I was surprised that Ayuko was saying that, because he's a layman, how? The trend was there, and this man saw it. But apart from that incident, knowing Ayuko he respects the law.
So how do we cure this negative perception?
Another one is Gloria Akuffo.
The former...
Yes.
And she recently said that the Supreme Court is becoming too predictable in their rulings.
No, you are confusing her with Sofa
Akuffo. Yeah, sorry. But, thank you for the correction.
Yeah.
But when we hear such comments that the Supreme Court is becoming too predictable in their rulings, what is wrong with that if they are getting it right?
If they are getting it, that's where the trouble is. Now, let's just wait a minute. What do you think is the reason why the Constitution will say for the adjudication of cases before it, a minimum of 5 Supreme Court judges should sit on the matter? It's because the matter is very weighty, difficult to handle, and they want the energies of different minds to come out and do their best, and then the end arrive at a decision. So, I mean, it's not impossible that given a certain line of cases, you'll find the court ruling the same way, but not virtually every case. You see? Because in the wake of this present constitution, the MPP brought a number of constitutional actions before the Supreme Court. A string of them were successful against the government. Those, when you read, you are convinced. But it was not in perpetuity, virtually in perpetuity.
But is that what
there came a stage where, decisions were going left and right, But
Justice, is there not a danger here where some of these comments put pressure on the judges such that sometimes even when it's right, they are looking at balancing their judgment to say that let's just go this way so that people will see this as being neutral. Shouldn't they just follow the spirit and letter of the Constitution?
No. Look, and that's one of the things. You see, I'm an insider. There are certain things maybe not. Look, if you are on the bench, you are worried or concerned about your image and the quality of your service, the judgments you come up with. You are concerned with that. You must make your mark. So if you are there and you are minded to operate that way, these sort of things will not bother you.
Right.
You are convinced on a proper and due consideration of the law. You have researched widely. You are convinced that these kind of things will not bother you because the righteousness of your judgment, a soundness in point of law, are there to defend you. And the Bar Association, if it is not politically jaundiced, they will sing your praises. They will uphold your judgments. But over the years, you know what has happened to the Bar too. That's another problem. You say it pretentiously, hey, you have to so and so. Me, I don't have time. I talk only about Ghana and the supreme interest of Ghana. That's all I stand for. That's all my concern. Don't care about any party. If you are party blue, party red, so long as what you are doing is right, I'm with you. If you are not and you think, maybe I should be sympathetic towards that, you are telling lies.
Do you think the Ghana Bar Association has lost its team? There's a new leadership in place. What do you expect of them?
This new level, they've just come on board. So you can only see how they operate when they react to important national matters or particularly constitutional legal matters.
But you think it's lost its relevance?
Look at the years. Those days of Ablǎzě, E.D. Com, J.K. Ajimang, and co. They were very professional. They were interested in the quality of the law, the soundness of the law, and they were standing on that to win their cases. And it gave them good light. And some advanced to the status of senior advocate of Ghana. Although later they said it was not duly, constituted.
All right.
But now there's legislation.
Let's look at what they're going. So, just before we take leave of you, election is just a few days, in fact, 25 days away.
Yes.
Okay, abusua we ne ensema ekoso ewo political highway so Justice Atuguba na echese waba be deti Chief Justice Torkornoo enye asanketo akra echese sa Supreme Court ruling na or ruling against Speaker Bagbin no echese ono so ababe backfire or more any easy cry. But the average for us some Japanese cocotis are odu way the my POG Media so what am I saying?